On Thursday, May 9th, the Karen Read trial continued with day 8 of testimony. And on this day, we heard from 2 witnesses, Christopher and Julie Albert. I've got to say, though, once it was announced that these 2 witnesses were testifying, particularly Christopher Albert, people were highly anticipating this testimony. However, at the end of the day, most of what came out was really not all that helpful to the prosecution, and there were some pieces that were in fact helpful to the defense. Let's get into it. Okay, so the first witness of the day, as I mentioned, was Christopher Albert. He's the brother of Brian Albert, the homeowner of 34 Fairview Road. Christopher is the owner of a pizzeria in Canton, and he's also on the Canton Board of Selectmen. This is a local government body that I'm not really all that familiar with, but based on my research, it sounds basically like a city council. And on January 28th, 2022, Christopher met up with the whole group of people that were gathered there at the Waterfall Bar and Grill. He testified that he also saw John O'Keefe and Karen Read come into the waterfall a bit after he got there. He testified that he had known them previously because they were neighbors and that basically they were more or less friends. Anyway, there were a few points that the prosecution seemed to want to present to the jury through Christopher Albert. This was after a bit more fluff testimony, to be honest, but eventually they did get there. The first had to do with Karen Read and drinking. And this is, of course, because there is a DUI charge against Karen Read that is included along with the murder charge. And what Christopher Albert said was that Karen walked in sneaking a glass with clear liquid in it. And what Christopher Albert said is that when Karen Read arrived at the Waterfall Bar and Grill, she walked in sneaking in a glass from someplace else that had some clear liquid in it.
When Mr. O'Keefe and the defendant come over to the area where you and your wife is, what, if anything, did you observe the defendant to do?
Well, when they came over, I think they started talking. At one point, when they first came over, the defendant came in with a glass underneath her jacket, and I thought that was kind of funny, and I laughed about it and made a comment about it.
And what, if anything, did you notice sort of about the glass? What was in the glass, anything like that?
It was just a tall, like, cylinder glass with some clear liquid in it and a lime.
And that was under a coat when she came in?
Yeah, it was like she pulled it out.
Now, we've heard testimony from a couple other witnesses at this point that they thought that Karen Read was drinking vodka from this glass. And so the prosecution probably wants to convince the jury that, of course, she was drinking enough to drive impaired. However, Christopher also testified on direct examination that he saw that by the end of the night, Karen was still drinking from the same glass that she had walked in with. So either she was going up to the bar to have that one glass refilled, or she was slowly sipping from the same glass which she had ordered previously from McCarthy's. And generally speaking, when someone goes up to the bar to order a new drink, they typically get a fresh glass with fresh ice and a fresh lime. You get the picture. Of course, it could be that this bar allows people to refill the same glass. And someone who maybe wants to obscure how much they're drinking might sometimes want to have that glass refilled as opposed to getting a brand new one. But on this information presented on direct examination, to me, it doesn't scream crazy lady who's been going on a bender then gets behind the wheel. Then again, the prosecution is still presenting their case in chief and might present more evidence later to convince the jury. But so far, from what I've heard, there's nothing here that jumps out to me to say that she was driving drunk that night. Now, another thing that I should point out is that Christopher also testified that he ordered a round of fireball shots for the whole group and basically just generally offered them. He said that about half the people that were there joined in to take one, but he couldn't actually remember who took a shot. Now, the prosecution probably wants the jury to think that it's possible that Karen took one, but the witness testified that he really wasn't paying attention to who took one and who didn't. So again, based on the information actually presented, not much in the way of points on the board for the prosecution on the subject of Karen Read drinking that night. Anyway, then Christopher said that he left the bar at about midnight and walked home. He said it was basically just starting to snow and hadn't really stuck on the ground yet. Now, I've pointed out the factor of snow serving as a potential timekeeping function in this case, and my thoughts from before continue on here. But anyway, he also said that he arrived at home at about 5 or 10 minutes after midnight. And this becomes important because the defense cross-examines him on it as being fairly crucial for timekeeping, not so much because of what it says about Christopher's activities, but what it says about the activity of his 18-year-old son, Colin. You see, on direct examination, the witness testified that his son, Colin, came home from being out shortly after he came home. Christopher said that he himself got home at 12:10 a.m., then immediately changed his clothes and jumped into bed and fell asleep. Then, about 10 minutes after he got home, his son Colin came home, popped his head in his parents' bedroom to wake them up and basically say he's home, he's safe, and good night, mom and dad. Now, this wasn't testified to, but apparently Colin had spent the evening at 34 Fairview Road, and the timing of him leaving 34 Fairview Road is very important to Karen Reed's defense. I don't know really anything beyond that about Colin and his activities, but I do understand that that is a sticking point for the two sides. And the jury probably has a sense that this timing is important because on cross-examination, the defense meticulously broke down the timing from the moment that Christopher Albert left the bar to the moment that he got home on Maple Street and his activities afterwards. And first, defense attorney David Yannetti pointed out with surveillance footage the exact time that Christopher left the bar.
Mr. Albert, you would agree with me this was clearly the end of the night?
Sure.
The lights are all on at this point?
Yes.
The bar appears to have largely emptied out?
Yes.
Okay, continue, please. Pause it. Oh, there we go. My co-counsel is much better at this than I am. Do you know who that person is who's leaving the bar at this point at 12:13 and 43 a.m.?
Christina, it might be better without that spotlight.
Okay.
You see it now?
That's fine.
Yeah. I believe it's me.
Continue, please. Okay. You can take that off the screen. So, having now viewed that video with the timestamp of 12:13 and about 43 seconds or so, does that refresh your memory as to when you left the waterfall?
Yes.
That would mean it would have been impossible for you to get home to Maple Street by 12:05 or 12:10, correct?
Correct.
Then Yannetti walked Christopher through the timing of things he did when he walked in the door and ultimately fell asleep. And this is where the timing definitely appears to be different than what Christopher originally testified to.
With regard to the timing of how long it took you to go home, I believe your best estimate is about 5 minutes? Is that your testimony? And when I say home, I'm not talking about from D&E Pizza. I'm talking about that early morning when you're at the waterfall.
I understand, yeah. I'd say around 5 minutes, I think, from the waterfall to Maple Street.
Fair enough. So now, if you're leaving the bar like close to 12:14, as indicated on the video, you're getting home somewhere around 12:19, 12:20, correct?
Roughly, yeah.
And what were you wearing that night?
Blue jeans, sneakers, I think, and like a sweatshirt.
Okay. And it had started to snow by that point.
A little bit.
So the ground was a little bit either slushy or wet.
Not slushy, but could have been wet.
Could have been wet. And the snow had not yet started to accumulate, or had it?
It didn't start, no.
All right. So you're walking home, but it was cold, correct?
Correct.
And would you agree that in the best case scenario, you might have had a little bit more clothing on for that cold walk home?
I think I had a sweatshirt on.
Right, but you could have used something else, right?
Oh, probably.
In light of the weather?
Probably.
All right, because you testified that by the time you got home, you were pretty cold, right?
Correct.
You hadn't, if it had been about a 5-minute walk, that was enough time for you to walk in almost shivering, correct?
Sure.
And given that there was precipitation, the snow had started, the sweatshirt would absorb the moisture as opposed to repel it, correct?
Sure.
And so you were wet as well when you walked in, right?
Sure.
And by that point in time, you were tired, correct?
I don't remember if I was tired, but
Okay.
I don't remember if I was tired at that point.
Okay. You had worked all day
Correct.
till late in the day, actually into the evening, correct?
Correct.
Taking pizzas in and out of a hot oven,
Correct.
as well as other food that you serve as well, correct?
Yep.
And you're now, and by the way, you'd had a couple of drinks or a few drinks, whatever it was, at the waterfall, correct?
Correct.
And you decided not to go to your brother Brian Albert's house, correct?
Correct.
That was in part because you weren't up for the continued partying at that point, correct?
Yeah, I just wanted to go home.
Right. And so when you got home, would you agree with me that your first priority would have been getting out of the wet clothes that you were in?
Correct.
And where would you have done that within your
In
home?
my bedroom.
And is this a townhouse? Or is it a freestanding residence?
It's a condominium.
Condominium? How many floors?
There's 3 floors.
And your bedroom's on the top floor?
Correct.
And the entrance is ground level?
Correct.
When you first entered the home in those wet clothes, where was your wife, Julie?
Upstairs in the bedroom.
And was she already washed up and ready for bed?
She was lying in bed.
And where did you go when you walked in the ground level?
I went up to the bedroom,
All right,
took off my clothes, jumped in bed.
all right. Do you have a master bath with regard to your bedroom?
There's a bathroom, yeah.
All right. That would have been where you brushed your teeth
But yeah.
and washed up?
But I did. That's where I would do those things, but I didn't do them.
You didn't
those
do
things.
either of those things?
No.
Okay. Did you grab a drink of water before you went to bed?
Nope.
All right, so you essentially came home, and I think we agreed it was around 12:20 or so, give or take a minute,
Roughly.
and you made a beeline for your bedroom.
Correct.
Did you fall asleep shortly thereafter?
Soon after,
Within 5 minutes or so? 10 minutes?
I started to doze off. I don't know exactly how soon after I fell asleep.
All right. Sometime within 5 or 10 minutes, would you say?
I would say more like within 15 minutes.
15 minutes, okay. So with regard to getting home, and we'll call it 12:19, because I think that's more consistent with what you said, and understanding that it's just an estimate. If you're walking in the door at 12:19, it takes you maybe a minute to get upstairs.
About a minute.
You kicked off your sneakers downstairs, I imagine?
Maybe. I don't remember. That was a long time ago.
Okay, and then you walked up 2 flights of stairs, right?
Probably ran up the stairs because I was cold.
Okay, all right. So you're getting up there around 12:20 or so, correct?
Roughly, yeah.
And you believe that you dozed off about 15 minutes later, which would have made it about 12:35?
Somewhere around there.
All right. Now, when you came home, you would agree with me that your son, Colin Albert, was not home, correct?
Not when I first got home.
And in fact, I think your testimony was that 10 minutes after you got home, he opened the bedroom door?
I think that's what I said, yeah.
Do you want to stick with that?
I'm just trying to recollect what I, thinking it over. So obviously it was a little bit longer.
Because you actually woke up when he opened the bedroom door, correct?
I don't think so.
Did you not just testify before this jury just, I don't know, maybe an hour ago, that you fell asleep and that your son Colin opened the bedroom door and woke you up to say goodnight?
Yeah, I guess that's what I said.
Okay. And when you testified to that on direct examination, that was when Mr. Lally was asking you questions, correct?
Correct.
And you knew that you were under oath at that time, correct?
Correct.
And you were trying to be as accurate as possible, correct?
Trying to be, correct.
All right. So in terms of the timing of this, assuming that he opened the bedroom door after you already fell asleep, if you're getting home upstairs to your bedroom around 12:20 and it takes you 15 minutes to go to bed, and that's around 12:35, then sometime after you're asleep, after 12:35, that's when Colin opens the bedroom door, correct?
I don't remember exactly.
Well, it's difficult for you to remember how long you'd been asleep for when Colin opened the bedroom door, correct?
Correct.
You don't know if it was 5 minutes, 10 minutes, or longer, correct?
I don't know exactly.
Right. But it was some time after you fell asleep.
To the best of my recollection.
Now, people who have been following this case undoubtedly have a good idea of what exactly it is about Colin's timing for coming home that's important. But at this point, the jury still doesn't know. But they do probably know that this timing is important for one reason or another, and that what just came out is that Colin, in fact, got home later than 12:30 a.m., probably more like 12:45 a.m. The significance of this will hopefully be clarified at a later date. Now, I will say that this was the best part of Iannetti's cross-examination of Christopher Albert. It was a longer cross, and most of it felt like a bit of a slog. And I'll say it wasn't his strongest cross-examination in this trial so far. Before this point in the cross-examination, Iannetti had spent a lot of time trying to dig up the connections of the Albert family with the former police chief Ken Berkowitz and with lead investigator Trooper Michael Proctor. And to me, as someone who's still learning about the details of this case as we go along, this part of the cross-examination didn't land as well as I think the defense was hoping. It was muddy, and it wasn't clear to me that the connections being drawn up were nefarious and beyond people just living in a small town knowing everyone else. The only thing that I will say is that there were some instances where the witness felt like he was trying to maybe hide or downplay some of the social connections, especially when it really just made sense for him to be more open and honest. And when a witness does that, the jury might start wondering if the witness is being shady.
You knew that Brian Albert, your brother, and Brian Higgins were friends, correct?
I knew they knew each other.
So are you saying that they were acquaintances?
No, I guess they're friends.
You guess they're friends?
Yeah, they're friends.
Was there something confusing about my question the first time I asked it?
Objection, Your Honor.
Now, also, Iannetti had a line of questioning about Christopher and his wife, Julie, referring to John O'Keefe as the Nebbercracker. Nebbercracker is apparently a reference to a character in the animated kids movie Monster House. I had never seen this movie myself, so I was totally unfamiliar with this reference until it was explained on cross-examination. But basically, the character Nebbercracker is apparently a crusty old grumpy man who owns a house and yells at kids to get off his lawn. And apparently, Christopher and Julie Albert assigned this nickname to John O'Keefe. You see, like I said, they were nearby neighbors of John O'Keefe. And it's undisputed that at one point, one of the Albert's kids had an encounter with John where he yelled at him to get off his lawn. But beyond that, the two sides were disputed on the details. On cross-examination, the defense tried to elicit from this witness that the nickname came basically from their 18-year-old son, Colin, being a menace to John on his property. For example, they made references to things like cutting onto the lawn, throwing beer cans and beer bottles into the bushes, and things like that. In response, however, Christopher vehemently denied this. And it seems that there is a connection that the defense is trying to draw here between the origins of the Nebbercracker nickname, specifically some tension or antagonism between John and Colin, and the events that occurred at 34 Fairview Road. And this would have been a much stronger point if the defense had receipts to back up these claims of Colin being this menace. Maybe it comes in later through some other testimony. But I was thinking in this moment that maybe there would be a text exchange between John and Christopher where John was complaining about John being a menace. And there was nothing. And then on redirect, Christopher had an opportunity to explain what he says are the actual origins of the whole Nevercracker nickname. He said that it was his son Dylan, who was much younger at the time, had crossed over John's lawn back before John had a fence around the front lawn. John saw that he was walking on his lawn, and so he yelled at him to get off his lawn. Dylan apparently was scared, and so he ran home and told his mother about what had happened. And so the two parents referred to John as a Nevercracker. Shortly after that, however, Christopher testified that John, in fact, called or somehow reached out to the Albert parents and basically apologized for having yelled at their son. Then apparently he asked for Dylan's favorite candy and brought over a whole bag of that, basically to apologize to him. And so from there, he says that they referred to him as the Nevercracker, but it was more of a light roasting of a friend kind of a vibe. And the defense had introduced some photos on cross-examination of the two of them, Christopher and Julie, on the front lawn or kind of straddling the fence of John's front lawn, basically to taunt him or tease him about being on his front lawn. And this really could be taken two different ways. Either they are tormenting someone who definitely does not like having people on his front lawn, or they are lightly teasing a friend and giving him a ribbing in a way that friends sometimes do. And I will say that in my experience, this is something that is fairly common with like dude humor, particularly in circles that are more military or police in culture. There are some guys in particular who will show the true depth of their friendship by giving their friends a ribbing on the things like this that occur. And sometimes those turn into like running jokes where they continue to rib on them. But I do understand that this can be taken in a completely different way. And it really depends on what John's reaction to these kinds of things were. And we really don't have that information at this point. But as of the cross-examination and the redirect, this whole line by the defense really felt unsupported. And I don't think it quite hit as hard as what the defense was hoping for. Now, maybe my opinion will change with more evidence. But I've said before that I'm going to call out what looks good and bad for either side, what lands and what doesn't. And this is just my impression at the moment. Okay, so that's Christopher Albert. The other witness for the day was Julie Albert, Christopher's wife. Julie was also at the Waterfall Bar and Grill on the evening of January 28th, 2022. She testified that she had a migraine, so she didn't drink, and she actually ended up going home earlier than everyone else. She also testified that she woke up when Christopher and Colin each came home. She said Christopher showed up at about 12:10 and immediately went to bed. Then she said that Colin came home about 10 or 15 minutes later. Now, after the cross-examination of Christopher, the jury might question her testimony on these exact times of these events. But the defense did not cross-examine her on it, and probably because they felt that they really didn't need to, since that information was probably still fresh in the jury's mind. Anyway, Julie also testified that it's her tradition that when any of her kids or nieces or nephews have a birthday, she gets up early, goes to Dunkin' Donuts, and buys a half a dozen donuts for them. Then she drops them by with a birthday card before they wake up. And on the morning of January 29th, 2022, she said that it was the birthday of her nephew, Brian Albert Jr. So she testified that she got up early, went to Dunkin' Donuts, and then at 8:30 a.m., swung by 34 Fairview Road to drop off the gift. And while there, she says that she was invited into the home where she was greeted by Brian and Nicole Albert, as well as Jen and Matt McCabe. And they were the ones that told her the news about John. Now, keep in mind, by 8 a.m., the police had already cleared that scene and taken away all signs that that front lawn had been a crime scene. But anyway, to my mind, her testimony didn't really seem to add anything new of substance for the prosecution. Perhaps the main point in her testimony was to try to corroborate the timing of Colin getting home in those early hours of January 29th. And that tells me further that this might end up being a very important detail. However, as helpful as this might be for the prosecution, her cross-examination actually opened up a bit of a can of worms from the defense. And this is really the first time that I think that the defense starts to make some headway on the whole the Albert family is super connected to the investigators and is probably conspiring to frame Karen Reed theory. What came out on cross-examination was that she apparently is good friends with Courtney Proctor, the sister of Trooper Michael Proctor. She's gone out with drinks with her, they've gone to parties together, and Julie has provided childcare to Courtney in the past. Now, to me, that all on its own is maybe an opportunity for some BS to occur, but it isn't proof on its own that BS actually occurred. But Then Yannetti got into some communications between Julie and Courtney, and things got a little bit more interesting. Specifically, he asked how often they would communicate and talk on the phone. Now, she responded that they talked very rarely, and this seemed to catch her up in something.
Do you deny that you were very close with Courtney Proctor?
No.
Okay. You talk regularly, correct?
Yes.
You text each other, correct?
Yes.
You also talk by phone.
Very rarely.
Is it fair to, did you say very rarely you talk
Phone.
to Courtney Proctor by phone?
Usually it's text.
But do you stand by that testimony that you talk to Courtney Proctor very rarely by phone?
Do we have a time frame? Do you mean now, or do you mean then?
Let me ask you this. Between February 1st of 2022 and September 6th of 2022, did you only speak rarely with Courtney Proctor?
I don't recall.
Were you using Courtney Proctor as an intermediary to communicate with Michael Proctor about this case?
Objection.
I'll allow it.
No, I was not.
Are you aware that between February 1st of 2022 and September 6th of 2022, you and Courtney Proctor spoke by phone 67 times?
Objection.
Were you aware of that?
No, I don't know the exact count.
Do you deny that you spoke 67 times?
I don't deny it, but I don't recall the exact amount of times.
Okay, so you don't deny that you spoke 67 times. You still want to maintain your testimony that you only talked very rarely with Courtney Proctor during that time period.
I just don't remember the exact amount of times.
Well, you know that my client, Karen Reed, was arrested in connection with this case on February 1st of 2022, do you not?
I do.
You spoke to Courtney Proctor that date for 12 minutes by phone, correct?
I don't recall exactly. I don't remember exactly.
And so then Yannetti brings up some of Julie's phone records to see if he can refresh her recollection about whether she and Courtney Proctor spoke and for how long on February 1st, 2022.
I don't recall.
Okay.
It's a long time ago. Thank you.
And you say that having seen this record, it does not refresh your memory that you spoke to Courtney Proctor for...
Don't. It does not refresh her memory. That's where you have to leave.
Okay. Did Courtney Proctor tell you the day of my client's arrest on February 1st that she had been discussing the case with her brother that day?
Objection.
Sustained.
Did you speak to Courtney Proctor that day in any fashion?
What day exactly?
The day of my client's arrest on February 1st of 2022.
That was on the sheet you just gave me?
It was.
Well, I did, obviously, if it was on that sheet.
Okay. And when you talked to her, did she tell you that she had discussed the case with her brother?
Objection.
Sustained.
Were you notified that Karen was going to be arrested?
Objection.
Sustained.
What did you discuss?
I don't recall.
The next day, February 2nd of 2022, was the day that my client was arraigned back in Stoughton District Court. Do you recall that?
Yes, I do.
You spoke to Courtney Proctor 3 times that day before my client's publicly televised arraignment at 9 a.m. Did you not?
Again, I don't remember.
After the arraignment, you spoke to her again for 27 minutes, beginning at 10:58 a.m. Did you not?
I don't recall.
Okay. So your testimony is, well, strike that. My client's arrest was pretty big news in Massachusetts, wasn't it?
Objection.
Sustained.
You were aware that my client had been arrested, correct?
Yes, I had seen it on the news.
You were aware that she was being arraigned the very next day, were you not?
Yes.
This case involved your family, did it not?
How do you mean it?
Well, you knew that John O'Keefe was found dead on your brother-in-law, Brian Albert's lawn, correct?
Correct.
So necessarily, your family was involved in this case, correct?
Somewhat, yes.
And you knew that ultimately you'd probably be talked to by investigators from this case, correct?
I assume so, yes.
Right. Didn't happen for 13 days, but ultimately they did come, correct?
Yes.
All right. So this case had to have been pretty big news within the Albert family, was it not?
Well, yes. Yes.
You were discussing it with your husband, correct?
Yes.
You were discussing it with your other relatives, correct?
Yes.
You were discussing it with your friends, correct?
I don't know about my friends, but
Okay.
yeah.
So is it your testimony that with all of this going on, you confined your discussions about this case just to your specific family members?
Not necessarily.
No. I mean, clearly, you would have talked to Courtney Proctor about this, correct?
Objection.
Sustained. So, folks, why don't we end here? All right.
So that's where her cross-examination got cut off for the day. Of course, it was definitely an interruption in what felt like a role that Yannetti was on, but I will say that Judge Cannoni has been very consistent about cutting off the day's testimony at exactly the time that she had previously planned to do so, regardless of whether it is the defense or the prosecution that is asking the questions at that moment. And still, the jury was left with the impression that Julie Albert may have been acting as an intermediary between the Alberts and Trooper Michael Proctor. It definitely sounded like typically over the course of their friendship, they would mainly text one another as opposed to calling. And it also sounded by the end of the day that all of a sudden on February 1st, 2022, the day that Karen Reed was arrested, they started calling each other and very, very frequently. The defense suggested that the records show that they called one another 67 times over a 7-month period. That would be almost 10 times a month, so roughly once every 3 days. Now, that phone record was not introduced into evidence, and that's because it has to be introduced through a witness with knowledge of the actual record itself. And although it is her phone that we're talking about, Julie really wouldn't be expected to recognize that particular phone record. If it gets introduced, I would imagine that it would come in through maybe the defense's digital forensic expert who conducted the data extractions from these phones, or from someone who collected these phone records otherwise. But if it's true that they didn't previously have a habit of calling each other on the phone and they occasionally texted, and then all of a sudden they started calling each other and once every few days, I'm sorry, but that looks incredibly suspicious.
Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious. Don't be suspicious.
John Ralphio?
But those are my thoughts. What do you think? Hey. Do you think that there might be some more evidence that the prosecution is sitting on as to Karen Reed drinking and driving? Or do you think that that's just a huge nothing burger? What do you think about the Julie connection to the defense's theory that the Albert family is conspiring with Trooper Michael Proctor to frame Karen Reed? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of the Karen Reed trial, both gavel to gavel live streams and daily recaps, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you for day 9.